This is Amsterdam. In this video we are looking at intoxication. So many offences are committed by people who are intoxicated by alcohol or other drugs, and these would not have been committed if it was not for the intoxication. However, intoxication cannot usually be a defence for such an act, and instead it is usually just a factor that is taken into account when imposing a sentence. So it can mitigate the gravity of the offence, and sometimes, as in dangerous driving, it can aggravate the gravity of the offence. Now, the law differentiates between involuntary intoxication and voluntary intoxication. So when the intoxication is involuntary, the defendant will usually be acquitted, whereas the law has never allowed the defence of voluntary intoxication in all cases. So this means that a drunken mens rea is still a mens rea. So first of all, we'll look at voluntary intoxication, as the defendant's voluntary intoxication at the time of the offence is generally irrelevant to his liability. So intoxication is voluntary, where it results from the defendant knowingly taking alcohol or some other drug. The two exceptions to this are when a drug is taken in accordance with medical advice, or when a non-dangerous drug has caused unintended consequences. So when the intoxication is voluntary, the next issue is whether the crime charged is one of specific intent or basic intent. Now, as a working rule, crimes with mens rea of intent are specific intent. So these include things like murder, and then Section 18 of the Offences Against the Person Act, 1861. Things like burglary and robbery are also things of specific intent because they all require intent. Now then, those of recklessness or negligence are then crimes of basic intent. So this includes crimes such as manslaughter, Section 20 or Section 47 of the Offences Against the Person Act, 1861, and so on. Now, if the crime is one of specific intent and the defendant was voluntarily intoxicated so that he lacked the mens rea for the crime, it means that he should be acquitted of that crime. Now then, after being acquitted of that crime, he can then be charged by one of the basic intent crimes instead. Now this does lead to problems though, because in some specific offences such as theft, there is generally no basic intent offence to fall back on. But this stance was confirmed in the case of DPP versus Majewski in 1976. Now this occurred when a man was convicted following a brawl in a pub where he had assaulted the landlord, customers and police officers. So the appellant used the fact that he was intoxicated as a defence for his actions. However, the House of Lords held that self-induced intoxication could not be a defence to a criminal charge in which no specific intent was necessary. So this meant that voluntary intoxication gave no defence to offences of basic intent such as battery. Now, an exception to this general rule is when somebody uses drink as a way of gaining courage to follow through with an action such as murder. And this was confirmed by Lord Denning in the Attorney General for Northern Ireland versus Gallagher 1963, and here the defendant had deliberately got himself drunk to give himself Dutch courage in order to kill his wife. Now, Lord Denning stated that getting yourself drunk in order to commit an offence means that drunkenness cannot be used as a defence to a charge of murder, not even reducing the charge to manslaughter. So in crimes of specific intent, the defendant may lack the necessary mens rea for the offence charged because of intoxication. Now, although intoxication does not negative mens rea, evidence of intoxication may be taken into account when deciding whether the defendant has the mens rea, and the jury can only convict somebody of a specific intent offence if they are sure that the defendant has the necessary mens rea. Now, under Section 8 of the Criminal Justice Act 1967, a person is not to be presumed to intend the natural and probable consequences of his act, and the question of whether the defendant had the necessary mens rea is decided by the jury and all the evidence. Now, the strongest evidence is that the defendant was too intoxicated to be capable of forming the specific intent. Now, it's also been established that the burden of proof is on the prosecution to establish that the defendant had the necessary mens rea. Now we need to look at crimes of basic intent though, because in crimes of basic intent, the defendant may be convicted of a crime even if the defendant was voluntarily intoxicated at the time of committing his actus reus, even though through voluntary intoxication, the defendant lacked the mens rea normally required for that offence. However, in the case of R versus Brady 2006, where an intoxicated man fell off a balcony onto the dancer below and inflicted grievous bodily harm, the Court of Appeal did hold that the fall was an accident and therefore the conviction was quashed. But an accident is not always a defence when intoxicated, and in the case of R versus O'Grady 1987, the intoxicated appellant killed a man under disproportionate self-defence, which was a mistaken belief. Now in this case, the court decided that a mistake of fact induced by voluntary intoxication cannot be relied upon for self-defence, and the defendant was convicted of involuntary manslaughter, which is an offence of basic intent. Now we need to look briefly at involuntary intoxication, because involuntary intoxication occurs when it's induced by a third party rather than being self-induced. Now this may occur when somebody has slipped alcohol into their drink, somebody has been spiked, or somebody has taken an intoxicant under duress. So the law takes a much more liberal view relating to involuntary intoxication and provides, by way of difference from the law relating to voluntary intoxication, that the defendant has a defence if his involuntary intoxication causes automatism, even if the offence is one of negligence or strict liability. However, involuntary intoxication is not always in itself a defence, because the defendant would have acted under an irresistible impulse. Now, this was established by the House of Lords in R versus Kingston 1994, when the defendant, who had paedophilic homosexual tendencies, was charged with indecent assault on a 15-year-old boy, and he tried to defend himself with the fact that he was involuntarily intoxicated, and this would annul his criminal liability. But it was decided that an intent induced by a secretly administered drug was still an intent, and the defendant was still convicted of indecent assault. So thank you for watching this video, and see you soon. Bye.